Hey Vibers, it's Kathy. Hi guys in chat. Look at you. Okay, I have to tell you a story before I start today's, which will weed out the people who say I talk too much. And I'm probably going to giggle a little, which will weed out the people who say I giggle. My giggle is terrible. Bye. Bye, guys. Don't let the door hit you. Anyway, okay. So one day I saw I'll Talk with Mike on my YouTube notification, and I didn't know why. I never looked at like court videos or anything like that, but I watched it, and it was great. It really was. It was awesome. I don't know, have no idea what he was doing that day, um, but immediately I watched every single one of his videos. And I thought it was great. So every day I would log in and see if he posted. Never did I catch lives, ever, ever. Um, and well, maybe once or twice, like a random live here or there, but they don't count. Um, but I would, when he was done, I would go to Big, and I liked Big N, but I didn't really go to all the other people. I went straight to the courts themselves. I'm like, I want to watch more courts, even though they're boring. Most of the court cases are so boring. Um, I don't know. Well, whenever I would find a good one, like I wouldn't go. I never went to Simpson and Middleton and Manning. They were covered. He covered them. Everybody was sending him clips in his Discord of the same hearing, like a minute after it started. Here it is. Oh my God. So I would spend my time and I would look for, judges that he never ever used. And I would send the clips to him. And then on his channel, he'd say, Hey, I got this clip from Kathy. Thank you so much. And I was like, Yay, yay. So, to make it easier for me to send clips to him, I started uploading the video on my personal one and sending the link to him. Well, when I did that, it was just the clip, no commentary, nothing, just the clip. And I had gotten a lot of um, viewers because when I sent it to them, they would come to my channel and they would view the clip, and I would get a lot of views that way. And Mike reached out to me and he's like, "Hey, you know, you're about to be monetized, and you can't really do that. It's against YouTube's policy to just put a clip up. You have to like say something or do something. You have to do something." So I was pretty annoyed because I didn't want to do anything. I'm lazy. I didn't want to do anything. Anyway, I, I was about to get monetized anyway, so I started the channel. And that's an experience all in itself, just starting a channel, because you have your personal channel, but then you got to convert everything and move everything. Well, back to what he said. All of those videos that I clipped and I posted on mine, um, some of them Mike used. I think maybe once Biggin used one. I'm not sure, but not everybody um, used. Not everybody saw them on Mike's channel. Like I have a lot of videos that nobody saw ever. Well, I mean, I got like 80 views. I got like 80 views, and I was like, "Yeah, Mr. Worldwide." Got 80 views. I'm so popular. But I have these clips. I had these clips, and they're really good. And I had to take them down because they were against YouTube's policy. And I didn't want to get in trouble. So, when I created my channel, I first thing I had to do is just remove all those clips. So I did, and now I have them. And now we're going to watch some of them here today. Um, we're going to start with my first Karen clip that I caught and I sent to Mike. And I'm positive Mike played this one. So you might have seen this before, but it's a goodie. It's a great one, so we can rewatch it. And then I found out what happened in the end. So after we watch it, I'll let you know what happened to Laura. What happened to Laura Kendall Miller? Laura, I'll be my own attorney. No, wait, give me one anyway. And this is when I first was keyed in on the whole hair thing. If you touch your hair, you're guilty. All because of her. I wasn't forced to take him down for impropriety. I don't do that. I don't try to do that. I don't try to get the really bad videos on here. Sometimes I do. But anyway, let's go to Laura. We're going to Laura. Think of Laura. And I'm sorry, this was when I was brand stinking new. So you're going to see me click around. You're going to see my mouse. You're going to see the screen do. I was new. I didn't know.
Jacob Ankle?
I have you, Mr. Ankle. Thank you.
Okay.
Okay, Judge, I don't know about the other two, but you can go ahead and proceed with who we have. Judge, you're muted.
Thank you. I'm going to jump to one case on the 10 o'clock docket because just State of Kansas versus Laura Lee Kendall Miller, case number CLW 2023 CR 69. Can you hear me, ma'am?
Yes, I can.
I spoke with Mr. Metcalf this morning, and I think he has conflict, so he has to be.
Can I represent myself, please? I don't need an attorney.
Very well, I will discharge Mr. Metcalf in this case. This matter comes on for arraignment. Do you know how you want to proceed?
I proceed in putting forth a not guilty verdict or a not guilty plea.
And look, I did not catch the part about how federal courts are involved.
Federal courts, sir?
Maybe I misunderstood what you said. You want to proceed without an attorney and enter a not guilty plea, is that correct?
That's correct.
Thank you. I will enter a not guilty plea. Mr. Audie, we probably need to have a in-person hearing. Do you want me to set this for a status hearing or a pretrial conference?
That's up to the court how you want to set it procedurally, whether you want to set a pretrial conference or just set it for a bench trial or a jury trial of Miss.
Jury trial when I'm completely innocent and you're taking eyewitness testimony from people that aren't even in Walmart. And I am going to subpoena the video footage there. And this is a complete waste of my time. This is the second time I've had to appear, the second lawyer that has a
Ma'am, we're trying to discuss procedures, not argue the case or the due process issues. What I'm going to do is set this matter for a pretrial conference in person in this courtroom. Mr. Audie, do you have any preferences on what day of the week to do that and how much time you think you will need, given that Ms. Kendall Miller will probably need time to decide how to issue subpoenas and prepare for trial?
Excuse me, I don't agree with the trial. It's completely unnecessary. And I know I have
Ma'am, you just,
trial.
ma'am.
I have the right to waive a jury trial.
Set the matter for a pretrial conference, and you will have your opportunity to discuss what you want the court to hear about the merits or whether or not the matter should proceed to trial. But we have to have that pretrial
I waive
conference.
a trial hearing. I'm sorry. I don't need, I know I have a choice. to let you decide or let a jury decide.
I'm going to set the matter
Representing
for.
myself, I want you to decide.
Would you please mute her? Thank you. Mr. Audie, what date would you like to have a pretrial conference?
I guess normally we would do those on a Monday afternoon, but that's during Judge St. Peter's docket. So I don't know, whenever the court wants to set an in-person hearing.
How soon would you want to be able to do that?
I don't need much time, and I think Ms. Kendall wants to, get this moving. So as soon as the court can get it on the docket is fine with me.
It looks to me like on May 8th that the only hearing that Judge St. Peter has at this time is at 3:30. And on May 8th, I don't have anything on the docket at this time, so we could do it anytime on the afternoon of May 8th. That would allow the state to address and have the court available, obviously, for Judge St. Peter. Would you like to do it like at 1:30?
That's fine with me.
Judge
I think we did set.
I'm sorry. He has some stuff that's not marked on the calendar yet on Odyssey. He has a 1:30, a 2, and a 2:30 so far as well.
Okay, can you look at his calendar for the 15th?
Yes.
And I do know Ms. Kendall is frustrated with having to miss work, so I wonder if it might be easier for her schedule if we do it late in the afternoon so she doesn't have to miss as much.
I will do it as late in the afternoon as possible for her.
Judge St. Peter has quite a bit on the 15th, but Judge Maslin, if you wanted to do a Wednesday afternoon.
If that will work for the state, I will do it at the earliest date that we can find courtroom time for an in-person hearing.
It would be the 10th because he has drug court on the 3rd.
Okay.
And anytime in the afternoon is fine.
We set it like 4 or 4:30, so that way Ms. Kendall doesn't have to take the whole afternoon off.
I'll be glad to set it on May 10th at 4:30 in the afternoon. Ms. Kendall Miller, will that work for you?
She's muted. Just a second.
You have to unmute yourself. Okay.
I would like to move that I have counsel appointed to me at this point, and then also that the court addresses me as Laura Kendall, my legal name for the past 6 years.
Yeah, Your Honor, her name changed and the court system for some reason keeps putting it down as Kendall Miller, but yeah, her name is Kendall.
Okay. So I apologize about that. I'm sure we can adjust that in future pleadings. So with the correct name matter addressed, you have an objection to setting the matter for May 10th at 4:30 p.m. for a pretrial conference in person in this courtroom in Winfield.
An objection? I'm okay with that date and time.
And ma'am, did you request another attorney be appointed just now?
Yes, I did.
Well, that being the case, I think we need to set the matter for review rather than a pretrial conference. But what's your opinion on that, Mr. Oddie?
I agree. And Laura, if you can contact since it's a misdemeanor case, if you can contact your attorney, they should be able to appear for you in the morning at the next hearing. And that way you wouldn't have to miss work, because I know that that's been frustrating for you.
Okay, a misdemeanor case. Okay.
I'm going to appoint Scott Loftus, who's an attorney who takes appointments in this county. What we need is your contact information so that Mr. Loftus can be sure to get hold of you. Do you want to give that to us now, or do you want to hold on?
I'll bring her Scott's contact information and then I'll get her new address at that time.
Okay,
So is it still Wednesday the 12th at 4:30?
no,
Sorry, Wednesday the 10th?
let's set it for attorney review for May 3rd at 10 a.m.
Okay.
Anything else we need to address on this matter?
I don't believe so. And Laura, just get in touch with Scott, and then he should be able to appear for you, and you wouldn't have to take off work that morning.
Okay, I'll call him. I'll get his information. Scott Loftus. Thank you so much, Mr. Audie.
Laura,
you.
if you hang out in the hallway, I'll bring you that information and get your address.
Thank you. I appreciate you.
Officer, who do you have with you?
So that was my first one. I was watching court videos by myself for no reason, and that popped on, and I was like, what did I just see? Was that real? And I recorded it, and I sent it to Mike, and then he played it, and I'm like, wow, this is fun. So that's how I got started. Anyway, I want to say hi to someone real quick who's not in our live, but should be. Hi, B24 Liberator. I love your comments. Thank you, thank you. You too, Texas Vernon, but you know that. Okay, now we're going to go to Simmons. This is less than a minute long, but I love her.
We're adding GPS title with victim notification. Not to be within 1,500 feet of wherever the victim lives, works, or goes to school, does her grocery shopping, does her laundry, gets her car serviced. Essentially, wherever she is, you can't be within 1,500 feet of that, okay?
Yes, ma'am.
Do you have any questions about car information?
This is still a $10 cash charity.
Oh, absolutely.
Okay.
Any additional matters?
Just from our classification, the no contact includes any sort of communications. Is that right, Your Honor?
All the types.
Emails or
All the types. Like, there's no possible types.
I would not.
Even if you created a type of communication that doesn't exist now, that will be included.
Yes, ma'am.
Okay? No problem.
Even if you created a type, you can't do that one either. Let's stay with Simmons.
Video, please, Mr. Russell. We're on the record in the matter of the people of the city of Lansing versus William Russell, file number 22-03247. Mr. Russell, today was the date set for show cause on this file. Because you owe $200 and you've not made payment, you were supposed to pay within 60 days back in February. What's your plan, sir?
Currently at the moment, it's going to be until I get the situation figured out and I get all the red tag and everything dropped from the city. So I'm not paying no fines until after I get the city taken care of.
I don't know what that means.
Because I'm getting the red tag removed. So if I get the red tag removed, everything's being dropped, everything's being thrown out, and they're going to owe me money.
Oh, is that what you think?
Yes, that's what I know.
you're actively working with the city on that. You're in bench warrant status on about 4 files.
Or yeah, because of the dog tags. I forgot about the dog tags. I've had so many cases back to back. It's just ridiculous.
Yeah, I would agree.
Well, I know it's harassment at this point from the city.
Well, I don't know. That
It
we
is.
can call this harassment, but
It is, because they've been trying to throw file after file after charge after me when they don't even have no rights to file for anything. So I do apologize.
So
I do apologize to you if I do. No disrespect to you, man.
It's not you failing to follow the city ordinances. That's just the city.
It's the city didn't file their guidelines and they wrongfully entered my home and so the city's in the wrong on this one.
Well, we're talking about your dog licenses. They're not. You don't.
Those
have
are for
one.
the bench warrant. Those are for the bench warrant that's out right now. Yes, I understand.
Yeah, you have 4 bench warrants. Yeah,
I agree with the 2 dog licenses. I understand that one, and I completely forgot about that date last month or last month. But all the other charges that I'm being, the $200 and the $25 is not getting paid until I get this all taken care of.
Money on the no proof of insurance. Is that city harassment too?
Well, okay. Well, I guess I don't know which one you're talking about.
Yeah. How about
You're
you
talking
turn
about my
yourself
ticket.
in on the bench warrants and we can address them? How about that?
It's
getting confusing. It's getting confusing for me. So the bench warrants will remain until you can appear in person.
I won't be appearing in person, ma'am. I'm sorry. No
Okay,
disrespect to you.
I'm not. It's no disrespect to me. I don't have a bench warrant. That's your business to deal with. You carry on and you'll get picked up on the bench warrant or you won't. Okay.
I just don't. Okay, so that's just the bench warrants are for my traffic tickets I got 2.5 years ago. Then correct?
Well, no.
years
You have
ago.
1 traffic ticket and 3 other files. So it's only 1 bench warrant for failure to pay. You have 4 other cases that are in warrant status. And for the show cause, you have not properly show cause as to when or why you're not paying. So a bench warrant's going to issue for that one too.
I have. Because I'm currently in the process. I'm not going to pay money out. I can't afford it right now. I'm not going to pay money out that I don't have. And I'm not going to pay money out to the city. So they're going to end up paying me back when they wrongfully charged me.
Okay.
For the other ones. Other than the dog tags. That's the only one I've
right
given.
You had the right in this matter to proceed to a trial, but you decided that you were going to plead guilty. And so you can't now plead guilty and then decide that you're not going to pay because it's some harassment. You pled guilty to allowing a suspended person. So you got to pay that.
I understand that, but as soon as I get my red tag removed, all this is getting dropped because of the tickets that they wrote me are going to get revoked because
the guilty plea is not getting dropped. You pled guilty to allowing a suspended person.
But I was told by my lawyer that if I get everything taken care of, I did have a lawyer at the time. Yes, I did.
Who was your lawyer? Who told you that these guilty pleas to amended charges were going to get dropped?
Was it Keith? I'm not exact. I can't really remember exactly what his name is.
Don't tell me Keithley.
I can't.
Because this particular case that you're show causing for today was issued in December, and Mr. Keithley was not here.
Issued in what? How is the show cause issued in December?
No, the case was issued in December. Show cause was issued in April after you failed to pay when you told in February that you were going to pay within 60 days after pleading guilty to an amended charge of allowing a suspended person to operate. You knowingly and willingly waived your rights and entered that guilty plea. Okay.
And my lawyer at the time told me that if I get all this red tag and all this taken care of and thrown out and show that the city's wrong.
I asked you, were any promises being made to you in exchange for a guilty plea? You said on the record, no.
I asked him that question about that, and I didn't realize that was part of it.
Under the penalty of perjury. I made you take an oath.
I understand that, and I didn't realize. I guess I didn't realize that what he told me. He was talking to me. That's my
going to issue for your failure to comply. So You'll have 5 bench warrants. You should turn yourself in on them, or if you want. It's up to you, okay? You have a good one, sir. Okay.
I love her. I just love her. She does such a good job. All right. This woman just decided to tick off her lawyer, which is always a great idea. Always.
Pretrial Gross, case number 225103. The record should reflect Ms. Gross present here in the courtroom today. I should have counsel put your appearances on.
Sierra Coke on behalf of the people.
I think you already go right there on behalf of Ms. Gross. She's your courtroom. It's entirely up to Ms. Gross how she intends to proceed today. I know she wants to ask for an adjournment. She indicates she's sick and would like to have the court adjourn this matter. So I would leave that in the court's discretion as well. As to resolving the case, I don't know her intentions. She's gone back and forth. So I leave that up to her how she wants to address that on the record.
Great. Well, Ms. Gross, we have the trial set to begin on July 12th. So the last month, so are we going to be going forward with the trial?
Yes, I guess.
I don't need to guess because this isn't a guess or maybe.
Well, no one's told me what my plea. Like, is there a plea offer? Is there? I'm just kind of really confused. I've been throwing up all day. I don't know. I heard Greg's plea offer.
Yeah.
Judge, the plea offer from Ms. Gross is to plead to possession of methamphetamine. Not double, the second offense would be dismissed. She's aware of this at the last time we were in court. She was aware of this yesterday. Aware of this.
No, I weren't.
She was aware of that plea offer before coming to court today. She was aware of the plea offer when she was in my office watching the videos.
Ms. Gross, your case has been going on for a long time. You've had lots of time to think about this, so now's the time you need to decide.
Okay, I will trial, Your Honor.
I'm sorry, what?
I'll just go ahead with the trial on July 12th.
Okay.
Yeah.
Fine.
Yeah. Thank you.
Ms. Coker, we're ready to proceed.
The people are ready to proceed.
We're prepared. We're ready to go.
All right. So, Ms. Gross, you need to stay in touch with Mr. Gurmurthy over the next couple of weeks. You need to be here at 8:30 a.m. on the morning of Wednesday, July 12th, here to go to the trial.
Okay. Thank you, Your Honor.
He just said that to the judge. He just made his own client look like an ass. But she threw him under the bus. So I forgot to tell you with Laura Kendall Miller, or Laura Kendall, she did get her bench trial in front of Maslin there. And she was found guilty of a protection order violation. And it didn't say what she did or how she did it, but apparently for what she said in that video, it was from Walmart. So that could mean anything up to murder in Walmart. But she was sentenced to 4 months and 22 days on probation. She had to pay $1,000 bail during this, which she paid. So because she paid that $1,000 bail, that covered all of her court costs and fines and everything. And, 300 some was returned to her. But to get to that point, yeah, murder in Walmart. To get to the bench trial, she burnt through 3 attorneys and was flipping back and forth about, representing herself. All right, let's do a custody case, shall we?
All right, we will go forward. I'm going to call a couple matters that I believe are going to be shorter. So let's first call Curtis Hart and Catherine Hart. I think they're both here. And Ms. Call is the guardian ad litem. I think I've set this on for today just to make sure there was contact with Ms. Cole and that we're moving forward on the guardian ad litem report. Ms. Cole, do you want to respond?
Yes, I've been able to do home visits with both parties. I've been up to kiddo's school and met with his teacher. I'd like to bring attention to the court that I found out in my home visit at Dad's house, at Mr. Hart's house, that kiddo is actually not living with Dad. He lives across the street at his grandparents' house. Yesterday, I received third-party information that there's a pretty serious health diagnosis that's been given to Grandma. And so I need to do a little more investigation to make sure that that's accurate and true. I'd also like to, based on the investigation at this point, I'd like to request, I asked Mr. Hart if he'd be willing to submit to a hair follicle test based on some allegations that have been made. He said he would not. So I'd like to ask the court to order that, as well as a mental health assessment. I'm concerned that this diagnosis of Grandma's is going to deeply impact Eric's living situation. So I want to make sure that going forward, if we have to make some living adjustments, that there's a healthy, safe place for him to be. Other than that, Mr. Hart has not provided me any collateral references to speak with. I've kind of just been finding these things on my own. At this point, I'm receiving lots of communication from Miss Catherine Hart and have had interaction with all of her collaterals and have received her tests.
Okay.
Am I frozen? There we go.
No, you're not. I have that your final report is scheduled for June 14th. Is that still a realistic date?
If I could request 2 more weeks to get some test results back and to have time to do a little more investigation regarding the living situation for kiddo, that would be really helpful.
Okay. Mr. Hart, do you want to respond to the request by the GAL that you have a hair follicle test and a mental health evaluation?
I don't mind. I don't mind having a mental health evaluation. I see no reason to have a hair follicle test. Just because she asked me if I wanted to submit. I don't feel like it's necessary. I don't use drugs. I don't have a history of drug use. I don't have a history of drug and alcohol abuse. So there's just no reason for me to do it. If you're going to order it, I suppose I will, but I just don't feel like I need to prove my parenting to the state. I've been involved with Eric, his entire life, not just a third. So, I mean, if you're going to order it, I will. I don't see it necessary. I don't see it being, I don't have money for it. The state doesn't need to spend the money on it. I'm not a drug addict. I've been in my son's life the entire time. So if it's something that you're going to order, then I will, but I don't see it being necessary.
All right. Let me hear from Ms. Hart. Any comment regarding this case?
Just that I've submitted months worth of clean negative UAs. I have absolutely no problem submitting to a hair follicle test. I've definitely been clean and sober for longer than 6 months. And Curtis has used drugs since he was 12. And so I believe that his heavy use of marijuana does contribute to a lot of his anger issues. And I think it would be an excellent idea.
Okay. Sometimes
Ms. Hart hasn't had any contact with me in 6 years, so I'm not really sure what she's talking about.
Your Honor, can I address this?
Sure, go ahead and then I'll make some decisions.
The request that I'm making is not a direct result of Ms. Hart's accusations. I've had multiple interactions with collateral parties who are concerned that drugs have been a factor and that there's very serious issues with anger management and harassment on Mr. Hart's part. This is not coming from one source.
Can I ask who these sources are? Because this is court. This is a public court. I got to know who my accusers are. If he's saying that people are saying that I have anger issues and drug abuse issues, that's something I would very much like to know. Who's saying that?
I think those individuals will be identified when the report comes out.
Okay.
gonna leave you on for now, so I'm gonna keep working on it over here. You okay with that?
Let me mute this person here. Okay. All right. Sometimes I will order a hair follicle test because we just want to have a level playing field and make sure where we're starting from. And if we're starting from a place of everybody's negative, that's great. But we need to have the test in order to determine that. So I think it makes sense to do that. So I am going to order a hair follicle test. I am going to order a mental health evaluation. You can do that either at Columbia Wellness, I believe, or Core Health. And you can talk to them about having that completed. I will extend the time for Ms. Call to provide her final report to June 28th. I'm going to strike the hearing on June 14th. And if there's any issues that come up, you can always note a hearing in front of the court. But in the absence of that, our next time together then will be on June 28th, and we'll review the report by Ms. Call.
Thank you. So am I going to get like a court order for that hair follicle test? And do I have to pay for that, or what's going on with that exactly?
That will be at your cost. I will do a bench order for it. It'll be available by tomorrow afternoon if you want to see the order.
So is that something I can fill out a fee waiver for, since it's being ordered on me?
I think you'd have to talk to the entity that does it. I think, well, I'm not sure where you're going to go to have that done. You'll have to talk to them to see if there's a way to waive that fee. I don't think I can do county pay on that.
Even though you're ordering it, you can't do county pay, even though it's a court order from the county?
Yes. Ms. Call.
Yes, Your Honor. I think it should also be noted that Mr. Hart told me in our interview that he and his wife, Amanda Hart, own a local spa in Kelso, and that is where he works and receives his income from. So while we were
I don't receive income from there. That's not true. I never said that.
Let's let Ms. Call finish, okay? And then I'll let you respond.
When I asked Mr. Hart how he supports himself and his son, his response was the income from the spa that he and his wife own together, and that he works for her and works there. I only give that information because this is now a county pay case, and he is asking for more county pay support.
Yes. That's because I qualified for that. I filled out the paperwork and I qualified. Therefore, there you go. Since you're bringing it up.
You'll need to talk to the entity that's going to do the test to see if there's a way to get the fees waived on it.
All right.
All right. Thank you. We'll see you back here on June 28th.
That guy. Yeah, that guy. You're right, Steve. It's everybody else's fault. When his test comes back dirty, it'll be everybody else's fault. And he was literally angry that whole thing, the whole time. So yeah, he might have anger issues. And I don't even understand what's going on, to be perfectly honest. These two have not spoken together for 6 years. And so their child is at least 6 years old by now. So in that amount of time, you would think this kind of stuff is worked out. Like they got custody worked out by now. What were they doing for the last 6 years? I mean, he said he's been in his child's life the whole time. Maybe he had custody. Maybe I'm thinking like she had custody automatically. Maybe he's the one who had custody this whole time, and now, I don't know. That doesn't make sense. Anyway, we're going to go with a very, very quick one. I just can't find it. There we go.
Tommy King.
All right, Mr. King, you've been charged with 1 count of terroristic threat.
You know who the fuck I am, and I wouldn't be charged with
Hey, sir.
I'm trying to talk.
Sir, I'm not going to hear that right now. You've been charged with terroristic threats or acts.
What's his last name?
His name was King.
That was Mr. King. That was Mr. King. All right, Judge, we can keep going.
He's gone. He's just gone. That reminded me of the clip that Josh sent where they took him to the ground. All right, I don't remember this clip being 8 whole minutes long, but it must be.
Good morning, how are you? Good, this is Kitty Joe Giles, clerk at 36th District Court. We have a Cassie Wilson that is assigned to your office, and no attorney has checked in on her.
So the attorney never showed up.
CASCIE.
That's spelled wrong, ma'am. My name is not spelled like that. It's KASCIE.
It's KASIE.
No, KASCIE. Kid, Andy, Sound, Candy, Ed.
That's what I said. CASCIE. Is that correct?
Candy, Kid, Andy, Sam, Carl, Ed. KASCIE.
That's what I said. That's what I said. CASCIE.
It doesn't start with a C. It starts with a K. I'm sorry. It starts with a K.
Oh, okay. I'm sorry. Okay.
Yes, ma'am. So mute me now, right? Because you're wrong.
Somebody lip read and tell me what she's saying. Something, I heard her say you're wrong, and something about paper. Oops, she unmuted herself. And don't worry, the attorney does show up. This is Giles, guys.
Morning, Mr. Baker.
Good morning. My apologies.
What case are you on?
I have Newman.
Newman, we don't have a Newman. You're on mute. Mr. Vicker, you're on mute.
I understand. Okay. I'm sorry. I meant to say Wilson. Excuse me. That's Wilson right there.
Yeah, she's in Division 1. She's.
Could I have a breakout? Could I have a breakout room briefly?
Sure.
Thank you.
Miss Wilson, I'm gonna put you in a breakout room with your attorney, okay?
Yes, ma'am.
All right. Accept the invite. You ready, Mr. Baker?
Yes. Hello.
All right. Calling case number 2356911, the people of the state of Michigan versus Cassie Wilson. Defendant is charged with count 1, robbery unarmed, count 2, larceny from the person, count 3, malicious destruction of personal property, $200 or more, but less than $1,000. Habitual offender, second notice. This matter is scheduled for a probable cause conference.
Good morning, Judge. People, P8659.
May it please court, Your Honor, Tyrone Baker, appearing on behalf of Ms. Wilson, P number 62647. Your Honor, I apologize to the court. I had a scheduling error. Excuse me.
Mr. Baker, you don't seem to be able to make it to my court on time at all, period. I mean, this is not the first time, it's not the second, it's not the third. I mean, it's, at this point, it's, I'm talking.
I understand.
No, I don't want this one on record.
I mean, you're gonna tie my hands.
Yeah.
If you keep doing it, I'm gonna show cause you. I don't want to do that, but and it's not that you are, 15 minutes late or 20 minutes late or a half hour late. You're hour and a half or more. You just don't show up at all. This is the only thing I can say. This is the last time I'm going to have a conversation about it. We understand each other?
Yes, Your Honor.
Thank you. Asking for a preliminary exam in this matter?
Yes, Your Honor.
Yeah. They held me back.
Now you see why I miss Judge Giles so much.
Are you available May 30th at 10:45?
Yes, Your Honor.
Anything else?
No, Your Honor, I'm all set.
Hearing, thank you.
Thank you, Your Honor. I'm supposed to contact me.
Does my bond continue? Will my bond continue?
Bond is continued.
Thank you.
Personal, right? You're supposed to contact me if you're released, okay?
Yes, sir. Thank you. Have a blessed day, okay?
You too. Take care.
Yes, sir. Yes, sir. I think I'm done over here, officer. Oh, I got the worst attorney. I'm not sure. He just went on me. Asking the same thing. Lord. He cussed me out for asking him why he was late. And then the judge tried to tell him the same thing. It's my life. You can't be late all the time. This is serious case.
Ms. Wilson.
Yes, sir.
Wilson.
Yes, sir.
You can hear saying.
Excuse me. I'm sorry. I'm finished. I apologize.
They were laughing at her when she was saying that. They liked that. So he's not the first lawyer that got that exact same speech from Giles in Detroit. Vanessa Hamilton got the same speech. I'm going to show cause you. And it's like, whoa, no. But the thing is, with these attorneys in Detroit, they are 100% overworked. And like Giles doesn't let you into his courtroom if you're wearing a sweatshirt or a t-shirt or shorts. So the lawyers are running around trying to find clothes and get to court on time. And they have to go to all these different courts every day. It's impossible. It's an impossible schedule. And they do it anyway. But Giles won't let up. And especially in trial. If you're in trial and you're a lawyer, God help you if you ask the wrong question. Because he will stop the trial right there. He will stop the trial right there to yell at you. It is amazing. All right, let's go back to someone else who just doesn't feel like paying. And we can agree or disagree on whether he should or shouldn't pay. But that's neither here nor there.
All right, Alonza Morris Teft and Michael Teft.
Here, Your Honor.
Is Michael Teft here?
Here.
Oh, good. I'm glad you're here. All right, Ms. Morris Teft has brought a motion for contempt for failure to pay the spousal support. We've been here before on that issue. She turned in a declaration indicating that Mr. Teft basically said that there's no way that he's going to pay it. Is that a fair statement, Mr. Teft?
That is correct.
All right. We're here about the third time on a contempt motion for failure to pay. And by the time we get to a third time, I start thinking about jail time. I want you to be aware of that. So if I'm thinking that, does that change your mind about making these payments?
No, I've already addressed with the courts, certain things, that, I wasn't even there. That's why I was in default. It needs to be looked into. Obviously, the judgment is going to be poor, especially if it goes to jail time, in my opinion.
And Your Honor. Just a minute. I think we talked before about you moving to set aside the default. How come you haven't done that yet?
Well, Judge, it's been a matter of emergency. I've lost my job. Transportation is usually the most reliable thing. Detriment has been caused towards my vehicle. I've had my tire slashed 3 times, broken windshield, and sugar poured in my tank over a course of the month. And the police have done nothing about it. All I could do is report it, Judge.
Your Honor, I submitted copies of what he's been having, receipts of what he's been spending money on, and how it also his pay stubs as well. I submitted all that today, showing that he has the money to pay and he chose not to. I also have a video of him saying that he doesn't give a F what the judge or the courts say, and that he wasn't going to pay me the alimony or the repayment that he was supposed to pay. And he said he didn't care that if you had sent him to jail or not.
And personal belongings have been stolen as well. That's how she received any form of receipt.
As well of him admitting all that, because I tried to work out with him and he chose
harassing. I did file a harassment order not too long ago, but it was denied for some reason. I understand it looks bad when I've had a protection order against her, but for some reason the judges never accepted that into any of the cases. So it just became problematic with the courts and just well-rounded problems.
That's a lie too, because I'm the one who had the protection order when I have the child. So,
all right, just hang on a minute. All right, I've got a decree of dissolution that was entered on April 14th, 2023. Requiring a payment of $650 each month starting May 5th, 2023. That decree was signed by Judge Basher of this court.
As well as a repayment of $3,113 that he stole from me, my tax refund that he stole when he kicked me out.
I understand that. We've already entered a contempt order on that amount, so I'm not going to enter that amount again. Each contempt order creates a judgment.
Oh, okay.
For the amount, so we don't need to repeat that. But we are in a position where we have a valid order of the court for that payment. I understand was entered because of a default. I think I have given that was in April. Now it's in June. I indicated Mr. Teft several times that he should move to set aside the default if he thinks he has the grounds. That hasn't been done. So I am going to enter a contempt order again on the $650 for May and June. I'm going to remove the $3,113 because that has already been entered.
I also have a video saying that he's not going to pay regardless. Like, I tried to work out payment plans with him, and he's over here lying, saying he lost his job and this and that. But yet he's spending hella money on buying, taking these little females out to eat and buying stuff for his car and just blowing money like it's nothing. But yet he won't pay what he owes. And I feel like last time he got a slap on the wrist because the court, he straight up told me right after court, "You're not getting shit," is what he said to me, and I have it on video.
All right, we don't need to swear on the docket, okay?
I was just trying to tell you what he said. That's all. I didn't mean to swear.
Golly, ma'am, we're in a courtroom.
All right, I'm entering an order of contempt for, again, May's spousal support of $650 and June's spousal support of $650. That was to be paid by the 5th of the month. It hasn't been paid yet. And I'm additionally ordering that Mr. Teft spend 5 days in jail. He's to report to jail on June 16th at 7 p.m. I'm going to put this over to next week, so this will be back on the docket on June 21 at 9 a.m. If Mr. Teft is not reported to jail, then I'll issue a bench warrant for his arrest based on that jail requirement. And sir, if you make a payment for June, that'll probably purge the jail requirement, but you'd have to make a payment and show it to the court.
So payments regards anything, or how's that work?
I'm going to set, well, I haven't issued a bench warrant yet, so I'm going to order that you spend 5 days in jail. If we have to issue a bench warrant, I'll set bail on that next week.
Okay, and you said it'll be, you're going to put it back on the docket for what day?
June 21 at 9 a.m.
How many contempt orders am I at?
There's about 3 at this point.
Okay. I'm not too familiar with contempt orders, but I'm not sure the stipulations around, how much time you can put around that, because those are things I'd actually like to consider. I mean, like I said, I stick to my point of view when it comes to my decision. I do want to contest the default, but it's just everything's been problematic lately. So I just want to make sure I'm fully aware of what contempt orders, because I don't have the legal help. But
you're in contempt because you're not complying with the decree of dissolution.
Yeah, that's what I was asking. I was trying to understand the limit of the amount of time you can put on a contempt order, because I mean, I know there's so many. I do have my point of view, and I can only consider the payments at this point, even though they're orders.
Michael thinks he's above the law, Your Honor. He thinks you don't have to follow court orders.
No, I just know my rights and wrongs, and there's a difference.
All right. Well, I would love to consider your point of view, but you need to move to set aside the default before we get there. Okay. There's a court order. You're not complying with it, and I'm ordering that you go to jail because it appears on the docket and from the declarations your failure to comply is willful.
can we move to set aside for a little time so I can set aside the default? Because if that was the case, you know, I'm actually trying to continue work. I've lost my job because of certain factors.
You can move. You need to submit paperwork on that, and you can do that at any time. If you can get it in by next week, I'd be glad to consider it next week.
Okay.
Okay.
And does he have to serve me a copy of those papers too, or no?
Ask that one more time.
You have to serve me a copy of those as well?
Yes, whatever he files with the court has to be served on Ms. Tuft.
Okay.
All right. Thank you both. We'll probably be here next week.
Okay, but he has to go to jail on the 16th, right?
Yes, that's when he's supposed to report to jail. But we'll be back here on June 21 at 9 o'clock. Thank you.
Thank you.
So, who thought that he turned himself in? I don't know, because this is in Cowlitz County, Washington, and I couldn't. So I'm on their site and I'm trying to look up case records, and you can get to the case records, but every time you try to pull up the details, like the complaint or anything, the site just spins and says, try again later, try again later, try again later. Well, I did, and then I gave up because I had enough. So I doubt he turned himself in. They're probably still fighting it. Well, no, they're definitely not still fighting it, because his last charge, he had 3 pages of charges, 3 pages long, was in 2023. Yeah, what's the over and under? All right. Let's go to Yancy. Let's go to Yancy. And
Are
she
the parties
stopped
ready to proceed with
putting
Mark
videos up.
Burns?
What was the last name again? I'm sorry.
Burns. Mr. Burns, please put your device on mute so we get ready to call your case, sir.
Okay. Yes.
Take an aspirin before you watch this, guys.
People versus Mark Burns, ticket number SP 123-25471, driving while license suspended. Ticket number SP 13182831. Driving while license are improper or invalid. Appearances for the record, please, starting with the attorney.
Bob Zaranick for Mr. Burns. Please state your name, sir.
Mark Burns.
So, Madam Clerk, can I ask you a quick question? Does he have any other tickets that aren't resolved or not on the docket today?
I can look for you.
Thank you.
You're welcome. Yes, quite a few. But there, a couple of them are past the time, or actually all are past the time to remove by the default, to be honest.
Well, okay, so Mr. Burns, those are the tickets we were talking about that I had mentioned to you were probably in default. And those are the tickets that you're money on.
Oh, so
these are the 2 matters that are up today that we had worked an offer out and a deal on. But the other ones are just in default.
The ticket, those tickets on the tickets of ticket number 5461 5462, and they were on the same ticket as they were wrote at the same time. And like I was saying, those tickets took 6 months to get into the system, and I kept calling down to Third District Court to get a court date, and they kept saying they wasn't in the system. If you look at it, the time frame on both tickets that was wrote were 6 months in a period of time that were in the system. So at that time, I had moved, and
time frame. I'm sorry to interrupt, guys, but it's still past the time frame. We're referring to ticket number. You said 461.
Hold on one second. I got the.
So had he had proper notice, though, would it have been past the time frame, Madam Clerk?
Well, he got these tickets back in 2021, but he did even still though. If they put him in March, I get that it is the 6 months, but he still would have had time to take care of them.
Well, no, what I'm saying is,
they actually gave a court date for it too. They actually gave you a court date for these tickets.
okay, what I'm saying is, Judge, I was saying that I had moved and I changed it with the post office. That's why I kept calling into Third District Court to get for the tickets for my court date and even to give my correct address. I'm no longer.
I'm going to use my discretion in this case, Madam Clerk, and set those aside. Just the ones that are in question about the dates and the time frame that he had moved.
Okay, so are we setting all of them aside, or are we just setting those two aside?
Just the ones that on the ticket number that he recalled and said
it was that 461, sir.
Well, okay. I just want to get in clarity of it. 461, 462, and 471 all were on the same ticket, and that's what I placed the bond for.
All
and
on the same day.
Yeah, and then the second set of ticket I placed the bond for was 821, 821, 822, 823, and 831. Those were all two the same tickets.
All of those were on the same date.
Yes, ma'am.
I'm not talking to you, Ms. Burns.
I'm sorry.
They were not on the same date.
Yes, they were, ma'am.
Sir, I'm looking at the register of action. They were not on the same date, and I can pull your actual ticket. You do not get these tickets all on the same day. You got one set of tickets in 2021, and you got the other set in 2022.
I understand that. I'm saying the two separate incidents, but those two tickets were those. The first date was 461, 462, and 471. That's one ticket. The second ticket
we understand what you're trying to say. You're just trying to say you have two separate tickets. We get it. I get what you're saying.
Tell me the two separate days, Madam Clerk.
Okay, the one date he got, the one offense date is October 4th, 2021. The other offense date was February the 23rd, 2022. So he got a total of 3 tickets on October the 4th, and he got a total of 4 tickets total on February the 23rd, 2022.
I'm only going to set aside one set of tickets only because, and let me tell you why, Mr. Burns, at the point, because I do understand the frustration of it maybe not being in the system if you were calling. However, once you got the second set of tickets in February, by the time the October tickets would have been entered, that would have been in March. Am I not mistaken?
That's correct.
Okay, so then you got tickets in February, sir. You could have definitely contacted the court in March and it would have been in there by then, and you could have, and that would have resolved that matter. However, as I am going to use discretion and set aside one set of tickets, and we could set aside the defaults on the, in all honesty, it's the 222 tickets that I would be setting aside, but that I should be setting aside, but I'll go ahead and set aside the ones from the 10-4-21.
The 10-4-21 is what ticket numbers? Or is that the 821, 822?
No, it's the 461 and the 462, sir.
Okay, can you set aside the February?
No, why would I do that? Why would I do that? I'm giving you a lot of leniency right now, Mr. Burns. Why would I do that?
I'm just asking, ma'am. I'm being honest with you. I'm just asking.
I just said I'm going to set aside one set of tickets.
Okay.
Madam Clerk, set aside the 10-4-21 tickets and add them. In all honesty, we probably need to come back to court. You're probably going to have to come back to court to find out what the global offer would be on the ones that we're setting aside. What are they, Madam Clerk?
One is failed to signal while turning, and then the other one is no proof of insurance.
Does he have his insurance down?
These are already abstracted to Secretary of State too, by the way. So he will have to still pay that $45 fee. Because we can't waive that.
I do for the February, the February last meeting. I had my insurance. I told the officer I pulled it out the window.
This is not a trial, Mr. Burns. It's not a trial. We cannot take your all the facts on the record right now. So on the failure to signal, we're going to set it aside and offer you blockading on those tickets, and the no insurance ticket will be dismissed without prejudice. If you like to accept the offer.
Okay, can you explain the offer again for me?
So for the failure to signal, we'll offer blockading, which is a $175 fee, and it doesn't abstract to the Secretary of State. And then I will dismiss the no insurance ticket with that set of tickets.
Okay, but that particular ticket is 126 on is that did it go up? Like I say 126 for that when you got the print when I got the printout.
Well, sir, you're taking an offer, which means that you're not getting a point. So that fines and fees are different for every ticket. So for blockading is 175.
Would you like to accept the offer, sir, or would you like to set this for trial? Because we have other cases that we have to do today before 12:30.
So to clear up that particular ticket for 461 set of tickets is 175.
Correct.
Plus your $45 fee for the no proof of insurance ticket because it already abstracted to.
And that's not a fee that I can waive.
Okay, so what about the driver's while license suspended?
We haven't even gotten to that yet because we're still talking about the tickets that you put into default. We have to call those on the record and do those now, all of them.
Okay. Yeah.
But is that what you like to do before I have my clerk set aside those tickets?
Yeah, so you're setting aside the no proof of insurance?
I'm setting aside the no proof of insurance and the failure to signal.
Okay. And it's 175 to set that aside?
No, it's not 175 to set it aside. Once I set it aside, I'm going to dismiss the no insurance. Okay. And then I'm going to have, if you're willing to accept the plea, you'll plead to blockading. That's the $175 fee. Then you have some other fees that has already abstracted to the Secretary of State that you'll need to pay.
Okay.
Is that what you would like to do?
Yeah, I mean, I'm trying to get my license. The whole point of it is trying to clear
and that does not include, okay, but that doesn't, and I just want you to understand that does not include what was on the docket for today. That's just the ones that were outstanding or in default.
Okay.
Madam Clerk, will you call those two as well as the ones that are on the record today?
Yes, Your Honor. Recalling the matter for Mark Burns, ticket number SP123-25471, driving while license suspended. Ticket number SP131-82831, driving while license are improper or invalid. Ticket number SP123-25461, failed to signal and turn on the curb. Ticket number SP123-25462, no proof of insurance. Appearances for the record, please, starting with the attorney.
Zeranic for Mr. Burns. Please state your name, sir.
Mark Burns.
Counselor, are you asking for a motion to set aside tickets that are in default?
We do, Judge. On those two tickets from 2021, we ask that the defaults be set aside.
So granted.
And Judge, there is an offer on that which Mr. Burns would like to accept. There is also an offer on the two on the docket.
Okay, what is the offer for the two on the docket?
Failure to display on the 471 ticket and dismiss the 831 ticket.
What was the charge on the 831 ticket?
831 was improper license.
And what improper license or improper plate?
Improper license.
Driving while license are improper or invalid, Your Honor.
And the one that he's pleading to failure to display, what was the original charge?
Driving while license suspended.
And those were on the same ticket?
Two different
tickets, Judge.
Oh, thank you. Thank you. Thank you for the clarification. Is Mr. Goss in there?
No, Your Honor.
Mr. Burns, what are you doing to get your license back? What have you done thus far to get your license back?
Clearing up tickets. That's why I'm in court. I paid the bond so I can come in forward so I can get my my license so I can be able to work. So, I'm just taking full responsibility to come before you guys right now to try to get
taking full responsibility, Mr. Burns, was to handle your matters back in 2021 when they came about. However, failure to display is not going to allow you to get your license back quickly. So
no bond was posted too.
Why not?
He didn't have a bond posted. He said he posted a bond. There's no bond posted for him.
I did post a bond. That's how I got a court date.
There is no bond posted, sir. I'm looking at your cases right now, and I'm able to look in a different system. You didn't post a bond.
Do you have matters in other courts, Mr. Burns?
Only matter I have in other court is what is it, Dearborn Heights.
These
And
are personal.
I go before them the day after the holiday at 2 p.m.
So the court does not, the court has a policy where we do not accept cash bonds on low-level offenses. So this would not have been a matter that you would have had to place a cash bond on or a cash bond. It would have been a $0 personal bond on these matters.
Okay.
Mr. Zeranek, in an effort, reluctantly, because we have already given so much leniency to Mr. Burns, but since he is trying to get his license back, we can allow him to plead to allowing an unlicensed driver to drive to allow him to do that more quickly.
Be perfect, Judge. Thank you.
All right. Mr. Burns, Mr. Burns, we can't see you anymore. I don't know if your phone is dropping. Did you have an opportunity to talk to Mr. Zeranek in the breakout room and he advised you of your constitutional rights, rights to an attorney, right to a trial?
Yes, ma'am.
Did you understand your rights?
Yes, ma'am.
Did anyone threaten you, force you, or promise you anything in exchange for your guilty plea today?
No, ma'am.
Are you pleading guilty on your own free will?
Yes, ma'am.
And are you pleading guilty because you actually are guilty?
Yes, ma'am.
Please raise your right hand. Do you swear or affirm that the testimony you give today will be the truth and the entire truth?
Yes, ma'am.
You can put your hand down. First, Mr. Zeranek, do you stipulate to the four corners of the ticket for the blockading? On the factual basis for blockading? And stipulate the probable cause on all dismissals?
Yes, Your Honor.
Okay. For the failure to display or actually allowing an unlicensed driver to drive, Madam Clerk, will you give a date and year, make, and model of the vehicle and location? Madam Clerk.
I'm sorry, I was just talking. I do apologize. On October the 4th, 2021, were you driving a 2004 Ford in the city of Detroit in the area of Grand River Avenue?
Yes, ma'am.
Did you come in contact with the Detroit Police Department on that day, sir?
Yes, ma'am.
When asked to produce a valid driver's license, were you able to do so?
No, ma'am.
Satisfied, Counselor?
Satisfied, Your Honor.
The court is also satisfied and will enter a guilty plea on behalf of Mr. Burns for the amended charge of failure to display. Also, the entering a responsible plea for blockading. All other matters that are on the docket for today will be dismissed without prejudice. Mr. Burns.
Excuse me, Your Honor. You said FTD not allowing.
Did I? Oh, I'm sorry. Thank you. Because I wrote down FTD. That was the original. Thank you for correcting. I'd like to correct the record that the court will enter a guilty plea on behalf of Mr. Burns for allowing an unlicensed driver to drive. Mr. Burns, the fines and fees for allowing an unlicensed driver to drive is going to be $220 in this case.
Okay.
And then the $175 for the blockading, which is statutory. And that is a total of $395. I understand that you have quite a few other cases that you are trying to get paid, but my advice to you would be to pay those as soon as possible because the $175 fee is going to go up if you don't pay it within the next 30 days. So you have 30 days to pay the $395. It will go up if you haven't paid it. I also need to see you back here on this Zoom on June 26th if you have not paid the $395. As long as you've paid it, you can ignore this court date.
So what's the total with both? You know, what that's the total I'm owing for today for both sets of tickets is $395.
Yes,
for the tickets that we set aside out of default.
No, I'm sorry, Brenner. He keeps saying both sets of tickets. It's not for all of your tickets. It's just for the four matters that we called into the record today, sir. And it's a total of $395.
Okay, so we were discussing the other tickets also.
The other tickets did not get set aside. I did not set aside the defaults in the February 22 matters. You still have the defaults on those and whatever those fines and fees are, but you will have to contact the cashier's office to determine that.
Hold on. I'm getting confused right now. You said you set aside one.
Mr. Zeranek, we have to put Mr. Burns in a breakout room for you to be able to explain that to him because I definitely have to let staff go to lunch at 12:30. So I'll place you in a breakout room so that you can get a detailed explanation, Mr. Burns.
All right.
Next matter.
Well, Mr. Burns, just go in your breakout room and wait there. I'll be in when the docket's over.
When the dock is over.
Yes, sir.
Yes, sir.
I mean, I've been on the phone since 8 o'clock.
Oh, has everyone else, Mr. Burns? Please place him in the breakout room, or you could come in person, Mr. Burns. I have to be courteous of everyone else on this screen today. I've explained it 3 times. I don't know what else to do. Go in the breakout room and wait for Mr. Zeranek to break it down to you step by step.
Go sit in that corner over there, and you stay there until you realize what you did wrong. I don't know how else they could have explained it, or why he doesn't understand that, he's got to pay for his tickets. He got so much handed to him today. My Lord. All right. Next, we're going to go to some guy who's very famous. But before we get to him, I'm going to start with the very end of a clip from a different one. And this is how Mr. Burns is feeling. This is exactly how he's feeling.
Hearing I'm sorry, when I say this file, I mean the felony file 236512 for hearing in about 30 days. Mr. Gill is obviously not here, but Mr. Brown, I don't know, through MIBC, what I'd like to see is one attorney.
That is generally the way it is. I don't know what happened.
So can you talk to Mr. Gill and get that reassigned?
Yes.
And then if that's up, the court will set that for hearing at the same time as these 3 files as well. Mr. Brown, anything further I can address for your side?
No, Your Honor.
Mr. Rowland?
No, Judge, thank you.
Okay. All right, Mr. Crisp, that's all for today. If you have further questions, you can talk to Mr. Brown, your attorney, okay?
Well, what just happened?
You can talk to Mr. Brown, he'll explain it to you, all right?
Okay. I'll talk to you. Thank you, sir.
Thank you.
Just relax. Just relax.
It's alert, like alert the building's on fire, sir.
Okay, yes, gotcha. All right, we're on the record in People versus Alert, case number 236520, 6521, 6522, and 6523. The record should reflect Mr. Alert is present here in the courtroom today, along with prosecutor Mr. Rolla. And we're set for status conferences in these files today. Mr. Alert, I believe the last hearing we had, your previous counsel, Mr. Seeger, withdrew from representation.
This is correct, Your Honor, and I actually was going to ask the court for a 90-day adjournment. I am continuing to talk with a new attorney because I feel like we can get a favorable resolution in all 4 of these files. So that would be my request, of course. And I do have a few questions if you have a minute, sir.
Okay, so it's been a month since Mr. Seeger withdrew.
Correct, sir.
So why do you need 90 more days?
Well, unfortunately, I've had 2 deaths in my life. One, my grandmother passed back in April, and the other, one of my best friends from high school, committed suicide a few weeks ago. At this present time, it's just been it's been a lot. So 90 days would be ideal. Now, with that being stated, I am talking to an attorney to get, representation, obviously, because I make too much to get public defense, and which I would prefer to retain my own counsel, of course. So that's my only request, Your Honor. At that point in time, 90 days should work for me, because at that point I'll be able to speak with my attorney and get the ball rolling, of course, because obviously we don't want to continue to wait, if you will.
Mr. Rowland?
Okay, I'm glad to hear Mr. Alert's indicating he has income. There is a plea offer which would resolve all of his files, and it will not matter whether he represents himself or whether he gets other attorneys. It's not going to change the plea offer of the prosecution. The plea offer is as follows. File number 236520, 236520FH. He pleads to count 1, financial transaction advice without consent. We will dismiss his habitual offender second enhancement. We found number 236521, financial transaction advice NSF check over $500. If he pleads to count 1, we will dismiss the habitual second enhancement. As to file 236522FH, that is 12 counts of financial transaction device overcharging. These accounts 1 and 4, we would dismiss counts 2, 3, 5 through 12 and the habitual second enhancement. And as to file 236523FH, which is again 3 counts of non-sufficient funds checks over $500. If he pleads to count 1, financial transaction advice, steal, use, retain without consent, people would dismiss counts 2 and 3 with habitual second as well. There is restitution total in all files of currently of $14,073.65. As far as a 90-day adjournment, since this matter's already been adjourned 30 days, the people think at the most that the court should consider 60 days, and that would be an outside number as far as further extensions. As to giving Mr. Alert the opportunity, he has to retain his own counsel, which is his right.
And then you said you had some other questions, Mr. Alert.
Yes, I do. So to one of my bonds, I'm not allowed to speak or communicate with Mr. Ventil. However, I just learned that Mr. Ventil, not from my own doing, from a close friend up here, has opened a new flower shop and as well has retained all of my equipment that has been purchased. I am working with an attorney at this present time, and I wanted to make sure the court would be okay if I would continue to work with that attorney, because it will be turning into a potential lawsuit at that present time. And so I don't know if that would be a possibility.
I'm not sure what you're asking with regard to the note. Are you saying you want to have contact with this individual?
I would not want to have contact. My bond states that I cannot, nor can I have anybody communicate with this individual. But with that being stated, within the new light of Mr. Ventil opening a flower shop, I would kindly ask the court to allow me to communicate through my attorney at that present time to Mr. Ventil and his legal representation, due to the fact that there is a conflict of interest there from owning a flower shop to now just opening up a whole new flower shop with all of my equipment that I own.
Mr. Rolla, do you have any objections about that?
Judge, obviously, as the court's well aware, even though there's a condition of no contact with this defendant, if the person who's allegedly representing Mr. Alert in the civil matter would be well aware that he would be allowed to communicate with that individual for court proceedings matters, and I think that's what he's asking about. I don't think the court needs to amend any condition, because I don't want to see, the people specifically do not want to see Mr. Alert trying to use that as an excuse to intimidate a witness. Otherwise, he'll be looking at additional 10-year felony charges of witness tampering or intimidation.
With that being said, Your Honor, I am no longer in the Oswego County range. I am within my bond limits within the state of Michigan. So at that present time, I agree with Mr. Rolla. I do not want to have any communication with anybody, especially from the note that you have seen from your assistant, Mr. Rook. I don't want to have any communication or contact at this point with anybody. And I just wanted to clarify that, because all it says in my bond conditions, I or nobody else should have contact through me. So if that would be okay with you.
I think you should have your civil attorney contact the court about that contact and notify the court.
It's just basically, and I can explain to you what it is. It's just basically a lawsuit and a cease and desist letter.
Yeah, I don't think we need to talk about the details, but if your lawyer in that civil matter wants to have contact with anybody involved in bond condition, then that lawyer should contact the court.
Okay, because I wouldn't really consider it a bond condition, since it's not going to be a buddy conversation. It's just a legal proceeding. But I understand for sure, Your Honor.
Okay. Did you have any other questions?
With that being stated, I'm very well known within the community, in a good and a bad way, if you will. And since I am no longer within the Oswego County realms, would it be possible from here on out to go into a virtual courtroom into Zoom just because there has been some circumstances where I've had some black numbers calling me to intimidate me, if you will. I don't know who those are. Those individuals won't, introduce themselves. I do have unlisted phone number now, so I don't have a situation with that. But, to give the court a little bit of background, I got up at 5 a.m. to get up here by 10 a.m. because I'm no longer up in the northern part, I'm in the lower part of Michigan. And my address is current as well.
So where our criminal proceedings are in person, if you're having problems, like you indicated in your letter, as well as what you're saying here today, then I think you need to contact law enforcement or the prosecutor's office to address those. It's not something that I can or would consider as a reason not to come to court.
The problem is the voices. I'm very familiar with voices. I don't want to name names because I don't specifically know, but it's been community members all the way up to law enforcement who have contacted me on block numbers.
I don't need to contact the Attorney General's office and my instinct to report it if you think somebody under the color of law is doing something improper.
No worries.
Then I understand why you wouldn't want to go to local law enforcement, but then the remedy is through the Attorney General's office.
Okay, yeah, I have no problem. I just wanted that well on the record so you knew about that, because for me it's extremely uncomfortable, to come back here because people know me very well. And I apologize for bringing it up, but your wife knows me very well from my flower shop. So that was the other question. Would you classify that as a conflict of interest since your wife is used to my flower shop? And the same thing for Mr. Rolla with for the Veterans Day. I don't know if that would be a conflict of interest or not. So
sure, and it's a small town, so myself and my family have contacts in the business world with lots of people that sometimes come before the court. If you feel that that's a basis for disqualification, then you're certainly free to file that motion, or once you retain counsel, they can do that as well.
Right, and these are just questions right now, so once I do retain my attorney, I can bring these up. So thank you very much for your time, Your Honor, of course.
And so, excuse me, I think in answer to your question, you're going to need to continue to appear in person for hearings. That's at this point, I'm not hearing enough of, validation of your concerns.
Okay, terrific. And I'll bring my attorney, once my attorney is involved, I'll bring it up to them, he, she, they, and then they'll bring it up with you and Counselor Rolla, of course.
Correct. So the court will set this for hearing in 60 days. I'll give you 60 more days. That would be a total of 90 from the last hearing.
Okay,
that's a reasonable amount of time for you to be able to retain counsel. Okay. And then at that time, we'll send you notice of the date and time of that hearing. Once you do retain an attorney, that person should file an appearance here with the court.
Yes, they will, for sure. No worries, of course. Yeah, no worries. And then just to clarify, I obviously don't want my address displayed on YouTube, of course. The address you have is the current one from, okay.
You can confirm that off the record with our clerk.
Yes, it's
downstairs if you want.
Okay, terrific. I will do so. I mean, it hasn't changed, so.
Okay. Mr. Roll, anything else that we need to address? Thank you, Mr. Alert. That's all for today.
Awesome. Thank you, Your Honor.
Every part of that made me cringe repeatedly. He's very famous and people are after him, threatening him. Well, I mean, if you wrote me a check that bounced, higher than the Empire, I might be after you too. I don't know. But he, his wife, the judge's wife and the prosecutor's wife have used that flower shop. So, of course, this is a conflict of interest. And, of course, he's going to sue the person that has a no-contact order out against him. And I don't even know if... Okay, hypothetically, I work for Bob, all right? Or I'm a co-owner. I work with Bob. Either, okay? Bob starts writing bad checks for the business. So they arrest Bob. The business probably shuts down if Bob's the owner. And he can't do business while this is all happening. Am I allowed to start a flower shop of my own? I mean, Bob I can't work with Bob. Bob's my income and it's gone. So even if he signed a no compete clause, I don't think that no complete compete clause matters if that business isn't running, right? Yes, Kelly, his address is public record. He's a criminal. It's really not hard to find someone's address. It's just not. And then it's hard for me to mute them in these streams though, let me tell you. They say that's so quick while I'm not paying attention. And then 2 minutes later, when I think everything's fine, they frickin' repeat it. And I swear so much when there's addresses. Because people don't like it when I accidentally leave an address on here, even though it's public record. I mean, I'm not sharing anything that is private. This is all public record. Unless, of course, you're in Calex County, where every time you try to get that public record, it keeps spinning, spinning, spinning. But even on that website, you know what I could get? All of his addresses. All of them. So those were my videos. Those were my clips that I had on my channel. I have more, but those are the ones that I pulled that I had to take down because there was nothing. There was no talking, no giggling. But I thought they were good. This flower shop one had one before it with this guy in jail, and he was funny. Wait, what just happened? I feel like that often when cases end and the judge is moving on. I'm like, well, wait a second. I don't even understand. How many years did he get? You said 1 billion numbers, but I don't know. How many years did that guy get? Oh, no compete clauses can't get in the way of you making a living, says Steve Miller, because he knows. He's been drinking whiskey in his coffee. Him and Sally Port. Oh, yeah, because he got laid off and he got another job with a competitor. You never get in trouble. Come on. Come on, Steve. Steve. And you are famous. People in Australia know you, right, Carolyn? So, I don't know. If someone has a no contact order out on you, and then you sue them, and, like, you lose. Like that lawsuit shouldn't have happened. Could that be? I mean, that could be harassment. That could be I don't know. Lawrence, hello. Yeah. But you can get your face in that camera. Yeah, I think she went to drink champagne. Champagne and caviar. All right, guys. I'm going to get off here so that I can go grab part 2 of the Australian trial and get it up. Let me just see if I have it here. I mean, I'm not going to play it now. It's like, yeah, I have it here. So I don't have to get up. Ha! I'm going to get it up on my site, though. I got to add that video game I was playing. That way, you know, I have to add something. And I don't have time to sit there and talk through the whole thing. So I just put a picture of the video game I was playing in the bottom right hand corner. That's called a loophole. A loophole that I know I'm going to get bad comments about. But that's okay. I'm happy with bad comments. Well, let me just tell you about this next one. There's this witness that's called that I am just in love with. Now, I didn't, when they take a break, watch her. Just watch her. She's flabbergasted that they took a break. It's really, really, It's really, really good. All right, hold on. Good night, Sheila. That was terrible. Steve, why did you make me do that? There's a subtle difference of big, famous, and infamous. Very true. 25 to life. 25 to life instead of 2 to 20. And then, oh yeah, I gotta get this court case up because court's open soon, even though it's Saturday and no court's open. I work a double today, so I don't know if I'll see you in 24 hours or not, guys. But it was fun. Thank you for watching my first clips. And you guys have a great weekend and happy Easter. Happy Easter to all of you. See you next time. Bye.